Good evening, ladies and gentlemen. On behalf of the AECCI-IAC, International Arbitration Centre, that is an initiative by the Asian Exporters Chamber of Commerce and Industry, Navi Mumbai. I, Swarn Dhiman, extend you all a very warm welcome, and we feel delighted to have with us today the students from LLB, LLM, law professionals, and the members from the trade and business community. So, dear participants, in this era of global trade, trade disputes are inevitable. But how do we resolve them? That defines the strength of any commercial relationship. Arbitration has emerged as a uh, preferred mechanism to resolve international trade disputes. So today's this 1 hour session will provide valuable insights on arbitration. So the title for today's session is Arbitration as an Effective Mechanism in the Era of Global Business Disputes. So very briefly, let me tell you about the AECCI-IAC, the International Arbitration Centre, IAC. It was established with the objective of promoting institutional arbitration in the matters concerning to domestic and international trade. Our idea is to promote, spread the awareness about the additional dispute resolution, to provide an efficient institutional framework, and supporting exporters, businesses, and of course, traders, small traders, I would say, MSMEs. And finally, we want to encourage the young law minds to explore the arbitration as a preferred career path. So, this is what we all are would be learning post this session. Now, before we begin with the session, let me give you some instructions to make the session successful. First of all, this entire session will be taken care by our esteemed speaker, and keeping camera on is mandatory. That has already been communicated to you all. I request you all to please keep the cameras on, and whereas you all participants will not be having mic access. So if in case you have any questions, you can simply put your question in the chat box. Towards the end of this session, we'll be taking up all your questions one by one. And now I take the privilege to introduce our esteemed speaker for today's webinar. We have with us Mr. Inbavijayan, who is highly respected advocate, international arbitrator and mediator, and the managing partner of Covey Global LLP. With nearly 3 decades of legal experience, he began his career at the Madras High Court in 1997. Since then, he is extensively focusing on arbitration and alternative dispute resolution. He has acted as sole arbitrator and counsel in over 400 domestic matters and several international arbitrations, covering a wide spectrum of disputes including international trade, banking, finance, construction, and joint ventures, investment disputes. He is empaneled as a member of AECCI, IAC, and is associated with several international reputed arbitration institutions across the globe, including Hong Kong, China, Dubai, Malaysia, Egypt, and US. He is also a fellow of the Chartered Institute of Arbitrators. Beyond the practice, Mr. Inbavijayan contributes significantly to the global ADR ecosystem as a course director, advisor to international institutions, visiting professor, and member of multiple prestigious arbitration bodies. We are truly privileged to have him with us today to share the insights on international payment disputes. Please join me in welcoming Mr. Inbavijayan. Sir, with great respect, I invite you to the session.
Thank you. Thank you, ma'am. Yeah. Thank you, ma'am. Hope I am audible.
Yes, sir, you are audible.
Good evening, one and all. These aspects like sovereign risk, currency control, enforcement, it is all about the litigation in national courts. National courts are designed for citizens, not for overseas sportsmen, not for foreigners. If you sue your buyer, particularly when you're going to deal with a buyer who is in a different continent or a different country, whatever might be, you face a normal court, home cooking, wherein the judges who know the local business owners socially, the lawyers who are actually the part of that particular judicial system, and the procedure rules design also exhaust outsiders. If they sue, if they file a civil case in that court, there is a high possibility of unfamiliar procedures, translation costs, as well as suspicion that you will get the home cooking. That is the home ground. It's all about how arbitration is to be taken up in the right sense to have the right outcome. I have to just confess that in this hostile era, arbitration isn't just a legal backup plan. It is really a strategy, a business tool for survival. You have to try to understand how to structure your contracts so that disputes are resolved in months, not in years. Then you have to structure how to freeze accounts across borders before even the buyer disappears. And we also have to understand how to sleep better at night, knowing that your legal remedy is as global as your supply chain. Now, we can just go with your nightmare. That is, I'll try to just find out and get you a particular escape plan. First thing, you have to understand why courts fail the global trader. For an example, I'll just give a illustration, a scenario. Assuming that you are an exporter in Ho Chi Minh City, Vietnam, you ship some $500,000 of consumer electronics. It's a very nominal cost to a distributor in Sao Paulo, Brazil. The goods arrived on time in apparent good order, no issue. The distributor signs a delivery note. Then there happened to be 45 days delay or later, just before payment is due, they claim that there is some defect in those particular electronic goods. Interestingly, the chips are failing. The screens are cracking. Eventually, they will refuse to pay because it is not as agreed. The price is $500,000. What's the option available? One party is from Vietnam, the exporter. The distributor is based out of Sao Paulo, Brazil. Normally, we will rush up to the Brazilian court where the distributor who is failing to pay the cost. The jurisdiction, particularly the contract, has boilerplate clause saying disputes resolved in courts of Sao Paulo or Brazil. You now have to hire a local lawyer in that city you have never even visited, or even if you have visited, you are not having much acquaintance. And interestingly, your Vietnamese legal team cannot appear at the courts in Brazil. This is one issue, that particular location. Another issue would be the language. Brazil has a national language, Portuguese. Your contract, your emails, your quality certificates, all might be in English. Eventually, this or all these documents have to be translated to Portuguese. It comes to few $1,000s. Third, we have the timeline. If you look on the Brazilian judicial system, similar to India, and sometimes even similar to Vietnam, more than 100 million pending court cases, the backlog of cases in the courts, and the commercial disputes of this size is not at all a priority for them. In an average, to get a judgment in the Brazilian court, it will take 3 to 8 years. Then there will be a possibility to appeal, then enforcement. And the worst nightmare, what we can encounter at the Brazilian part is the court proceeding is public, everything is public. Your competitor, assuming that he is in China, particularly Shenzhen, reads the court docket, they come to know, they learn about your profit margin. It is somewhat higher than 10%. Your other suppliers and your payment terms, all these would be an issue. And you will end up in a huge mess, not only with this particular transaction, but in other future transaction or the transaction which you have done earlier. Another option is arbitration. I'm not just trying to say that arbitration is best, but we are here to just understand the better options. When it comes to arbitration, the seat, forecasting the contract geographically, Vietnam and Brazil. In between, you can even choose a seat, which can be even Chile, or it can be even US, or it can even be Singapore, depending upon the arbitration system and the law in that particular jurisdiction. Regarding language, you can very well agree on a common language. Neither Vietnamese nor Portuguese. You can go for English because the language of the contract is English. Here, ultimately, we need not go for translation. The cost on translation is being minimized. Timeline, when you take on many of these prominent arbitration seats, we can complete the arbitration within a maximum of 12 months. In India, we have that concept. Other countries, it is 12 months or even lesser, sometimes even 6 months. The process is confidential. It is not publicly available. Even though it is confidential, the outcome of that process, which is called, and not a judgment, but an award, is binding. And there is very limited possibility to rule over that binding or even go for an appeal on it. Coming to this scenario, why does this matter now? Most of the time, there is a say, the supply chains are fragile. You cannot afford to have $500,000 tied up for a longer period. In a Brazilian court, it can even go to the level of 8 years or 10 years. At an 8% cost of the capital, that particular example, some 40 or 15,000 US dollars per year is a lost opportunity. In trade, cash flow is oxygen, and arbitration is going to be the ventilator that keeps your business breathing. When it comes to importers, you literally are going to fear being stuck with the defective goods. It is all about a container of smartphones that don't turn on or fabric that disintegrates after one wash. Arbitration allows for emergency arbitrators in most of these jurisdictions so that that arbitrator can issue an order to preserve the goods, freeze the bank account, and also require a third-party warehousing to hold the shipment pending in the final decision. Now, all these makes us shy away from the local judge. There is no waiting for the court hearing. Just a professional, technical person, an arbitrator who understands the value of money and the value of time would deliver the judgment that is the award at the earliest possible time. The courts are for disputes about the past. Arbitration is for the dispute that's going to affect tomorrow. Now coming to the greatest advantage of we can say, the superpowers of arbitration. The first one is neutrality. We are now trying to move away from fear to power. Arbitration gives you three superpowers that litigation cannot touch. Any part of the world. These are not theoretical ones, these are practical. They are the reasons that over 90% of Fortune 500 countries use arbitration in their international cross-border contracts. When you take on the first one, neutrality, there are countries like Switzerland. Switzerland, many people would be interested to go for tourism, but interestingly, Switzerland is a jurisdiction which is prominent for neutrality. When you're going to draft your contract, you're going to decide the rules. You can write like disputes will be resolved by so-and-so institution, arbitral institution, applying English law of contract with the seat in Switzerland. Here comes the question, why is so powerful? Why we are going to say this to be super powerful? It is because neither you nor your counterparty goes home. You both meet in a neutral territory. That's very important. It is not going to be Vietnam. It is not going to be Brazil. You are going to find a neutral territory. Further, the arbitrator isn't your local judge. You might even consider that not even a local judge, or he's a professional. An arbitrator is a professional, often a former judge, a law professor, a senior lawyer, a common professional, or even sometimes a trader. They are hired for their expertise in international sales, letters of credits, that is a documentary credits LCs, or even in court terms. This is the first superpower what we can encounter when we are just engaging with arbitration. When we just go to the second one, it's about enforceability, execution. This is considered to be the single most important legal fact you will hear today. You win a judgment in a local court, assuming that that court is in Italy, against a buyer in Indonesia. You have a wonderful piece of paper that is a judgment. Now, we have to go to Indonesia. Indonesia does not automatically recognize the judgment given by an Italian court. You must start a new lawsuit in Indonesia to encourage the Italian judgment. That might take an average of 3 to 5 years. This is the greatest challenge of enforceability when it comes to courts. But in arbitration, when it comes to enforcement, if you win and get an arbitral award, there is an international convention, which is called the New York Convention, which has been signed by more than 172 countries, including Vietnam, Brazil, Indonesia, Italy, India, UAE, United States, major trading blocs. Everyone has signed it. And if you look on that convention, when you take your award to a local courts, the Italian arbitration or a neutral country arbitration, and taken it to Indonesia, particularly in Jakarta, the judge has no discretion to re-examine the case, particularly the merits of the case. They must enforce that award. This can happen within 3 to 6 months, not even a year. This is the advantage when you offer arbitration, particularly the superpower that is enforceability. When it comes to importers and exporters, for an importer, if your Chinese supplier breached, you get an award from Singapore or even Hong Kong. You take that award to China. They can very well enforce it. They can even freeze the supplier's bank account. They can seize the goods in their warehouse. All things is possible as an importer's perspective. In the exporter's perspective, if your US buyer doesn't pay, you get an award in London. You can very well enforce in the New York Federal Code under the New York Convention. And literally the bank account of the US buyer would act as garnishee, that too within few weeks. The enforceability execution becomes the second superpower. The third one is about confidentiality. In litigation, everything is public. The complainant, the evidence, the motions, the judgments, all available in public domain. Your competitor eventually would come to know that you had a quality failure, your margin is so and so, your supplier is unreliable. All things, unnecessary issues would come out in public, which has to be kept private and confidential. In the arbitration, nobody would come to know about it. The dispute, the evidence, the hearings, including the award, it all stays in that particular room, whether it is a physical room or a virtual room. The arbitrators are bound by confidentiality rules. The institutions do not publish awards. And if at all they are going to publish awards, it is with redactions and consent of the parties. Now comes the question why this is a significant matter for trade professionals. It is all about reputation in everything or trustworthiness. A single public lawsuit can destroy a trading relationship. Arbitration allows you to fight, settle, or even win, and then walk away without a public scar. Very important. There is no issue on when it comes to arbitration. The takeaway from this, the superpowers, is that a major commodity trader had a dispute with a state-owned enterprise over certain tons of soya beans. They arbitrated quietly, they settled confidentially, their competitors never knew about what happened, and ultimately that's the value of silence. The neutrality, enforceability, as well as confidentiality, the three, which is the thumb rule of arbitration, helps you to come out with an effective trader even if you have a dispute. Now comes the question how to just take it to this arbitration instead of finding a particular court jurisdiction. Literally, we are just going to get involved a practicality, the reality. This arbitration mechanism is only effective if it is in existence before the dispute, that is at the time of entering into the contract itself. You cannot add it later. Once the dispute has arisen, the other party has no incentive to agree to a fair process. They will obviously insist on their home country courts. Normally, as traders, we come to do a common mistake saying that in the case of dispute, the parties shall arbitrate in a neutral venue. Literally, such a clause in a contract is like a garbage. That is a ticket to a procedural war where we are going to do the arbitration. What is a neutral venue? Whether it is Switzerland or whether it is going to be the moon, outer space. Who is going to appoint the arbitrator? What rules shall apply? If we have a clause like this in case of a dispute, I am going to the golden rule. That is, I am going to include an arbitration clause which covers entire things. I'll just read out a particular clause. Any dispute arising out of or in connection with this contract, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration administered by the ICC, that is the International Chamber of Commerce, International Court of Arbitration, or AECCI International Arbitration Centre, in accordance with its rules in force. The seat of the arbitration shall be specific, the city. It can mean any part of the world. The language of the arbitration shall be English. The tribunal shall consist of one arbitrator, and the governing law of the contract shall be a specific law. When we have such a clause, this is a golden rule. Normally, when you enter into the trading part, most of us just do the trading based on purchase orders. In purchase orders, the party's name, the port of origin, the port of destination, the price, the quality, the mode of payment would be common. Along with that, just add this arbitration clause. If we're dealing with Chinese parties, they do have, but it will be facilitating Chinese arbitration. But nothing wrong in it. Still, it is an arbitration. Now, looking into such clause, this is nothing but a broader understanding which covers all type of disputes, whether it is tortious claim, whether it is fraud, or whether it's a dispute which is sometimes not directly even related to that particular contract. Here, when you're just trying to finalize a contract, it is all about how you're going to negotiate. You have to script your renegotiation skill. It's very important. Don't ever attempt to sign a model contract. Model contracts are just template you have to customize according to your needs, both parties' needs. It's not only confining to you as an exporter, but also as an importer. It has to be renegotiated. And when we are just going to renegotiate, we can very well bring to a clarity stating that we are updating our standard terms to protect both of us in the current volatile market. This arbitration clause means that there is a dispute, we resolve it quickly and neutrally in a common jurisdiction with English law as one arbitrator. It will minimize the legal cost for both sides and avoids years of litigation. Such type of renegotiation communication is very, very important. Assuming that if they refuse it, you are trying to renegotiate and they are saying that we cannot renegotiate, we cannot change, then it categorically tells you everything about their intention. A counterparty who refuses a neutral arbitration clause is planning to use the home court advantage against you. That's very important. They will be very, very, very skeptical about it. But you have to be really cautious. What's the caution you need to have is that in 2021, when I personally had an opportunity to deal with a Chinese exporter and a German importer, they had a defective clause in their purchase order. In that, it mentioned arbitration in China. But fortunately, the German party won the case, but the Chinese court set aside that award. That is, in appeal, it was challenged and they annulled that award. And the clause did not specify the institution. Because in China, arbitrations have to be conducted only through institution, not by the parties on their own. Ultimately, in that, the German party had to start over and they had to do the entire case in the Chinese court. This is the golden rule. We had to be very particular renegotiating the arbitration clause. Another one is the cost myth. Many of us would have heard that arbitration is expensive. But this is a myth. Most of the time, we'll try to say councils, arbitrations have filing fee. Arbitrators charge very high fees, sometimes even more than $500 per hour. Lawyers' bill would be quite higher. And it's a sophisticated process. Still, litigation is cheaper. You must file a complaint and show up. All these are quite a common discussion we'll come across. Litigation is expensive, no doubt, but arbitration is a softer one in it. Now, I'll try to debunk the cost myth with some hard numbers, some hypothetical numbers for you to understand. When it comes to litigation, cross-border litigation, the same example of $500,000 US contract, 5 lakh US. The filing fee might be a maximum of $500 US. It is cheap. Service of processes on a foreign party, it can even go to the level of $5,000. Local counsel in the defendant's country, it can go even to the level of $800 per hour. Your advocate's fees, $600 per hour. The translation of the documents, in an average, $15,000 US. And court appearance can go even for 40 sittings. And in an average, it comes around $1,20,000 US. And then it goes on for appeal. And that's a time factor, additional $1 lakh. For a dispute of $5 lakh, in an average, $3.2 lakh you have to spend in courts. And it is not going to happen within a few weeks or months or not even within a year. It can go to the level of 5 to 6 years. The total cost of litigation considering the year, we have to have a comparison with arbitration. When you go for arbitration, normally the institutional filing fee would be in the range of $10,000 US, really high. Arbitrator's fee would be $800 per hour. Administrative fee would be $15,000 US. The counsel fees might vary depending upon the lawyers from which jurisdiction you are finalizing. And it is not going to happen for longer hearings, not like 40 or 50 hearings. It can complete within 5 or 6 hearings, and there is no appeal. When you have a calculation for the same dispute amount of $500,000 US, the cost of arbitration would be in an average of 1 lakh US dollars. In courts, it can go to the level of 3.2 lakh US dollars as an average, but in arbitration, it is hardly 1 lakh US dollars. Still, it is higher, but comparatively, it is better, and the time taken would be in an average of 6 to 12 months. Arbitration is often half the cost and 1/10 of the time which is going to be taken for litigation. But still, we need to find the real challenging one. The opportunity cost. Most of us, we are entering into the exporting or the importing market is for creating our opportunity. Here, the opportunity cost has to be worked out. With the same example of $500,000 US dollars, if it has been tied up in litigation for an average of 5 years, and a cost of capital is 8%, that is around $2 lakh in loss and opportunity. When you come to arbitration, that amount can be freed within a year. The cost of capital might be 40,000 US dollars. You are going to save around more than 1,50,000 US dollars just in financing cost. Comparatively, the cost is reasonable. The bottom line, what I'm trying to say is that arbitration is venture capital for your dispute. We have to be very clear. It is a venture capital for your dispute. You pay more upfront to get a faster, smarter, as well as enforceable result. It's all about, we have to realize, we have to execute that outcome. Litigation is considered to be like a payday loan, which might be cheaper to enter, but it will ruin when it comes to existence. It's very hard to survive going along with litigation. Now, many of you would have heard about another aspect internationally when it comes to cross-border, many are facing now, is force majeure. F-O-R-C-E, force majeure, M-A-J-E-U-R-E. Even before this Middle East conflict, we had a conflict between, which is even continuing between Russia and Ukraine. The Ukrainian corn exporter example, I had a real-time example to share with all of you. A Ukrainian corn exporter, and there was an Egyptian feed importer. The contract was to the extent of not much. It's about 50,000 metric tons of corn, which is normally higher, but normally they were doing much higher volume. And the deposit paid was $2 million US dollars. It was, I think, in the mid of February 2022, Russian invasion started. That particular ship, which was sailing in the Black Sea, got stuck. The exporter wanted to say that it is a force majeure, a war. I keep the deposit, my costs are sunk. I'm trying to say, as an exporter, the Ukrainian exporter mentioned. But the importer said that you did not even load it. You have to return the amount, that is $2 million US dollars. And force majeure doesn't comes as an excuse returning the unpaid money. Here, how to handle this force majeure? Force majeure normally has to be a similar act of God. War is also sometimes as an act of God, but to what extent it is being spread, that matters. When it comes to the courts are very, very rigid, and the court won't apply the common universal principle. They will apply their own country laws. In arbitration, it is quite very clear. they look into seriously the force majeure and the applicability. In this case, the outcome in arbitration was that we spent 4 months around, I think, from March itself, March till July, August 2022. And we are just literally trying to argue where to arbitrate. The Ukrainian exporter wanted Kyiv, which is impossible because of the war. The importer wanted to have it to be in Cairo in Egypt, which might be favoring one party biased. And finally, they were so conducive to agree a neutral place, Vienna in Austria. Later, they wanted to apply which rules to be. It took around 7 months to even appoint the arbitrators. It was, I think, December 2022. Meanwhile, what happened to the edible product, corn? The corn got spoiled. But the ship also got released. Both parties had spent some around $2.5 lakh on preliminary aspects. The final award, the judgment in the arbitration came around mid of 2023, June 2023, around 15 months after the dispute arose. Here, technically, the importer won. But here the exporter had already moved the deposit to an untraceable account wherein enforcement has become impossible. This also happened in arbitration, I'm trying to say. But we do have a better options when we properly agree on the golden arbitration clause. If in the clause itself we would have just specifically mentioned Vienna and some arbitration institution in Vienna, literally you would have saved some 7 or 8 months. The particular subject matter, the corn, would have not been spoiled and they could have very well settled amicably the dispute. One thing, participants, we have to be very clear. We live in an era of global business. Everything we have to just purchase across borders. Sanctions, shipping delays, currency collapses, pandemics, war. These are not the events which you can anticipate, but still they are the events when. We can't say if, we have to say when. Arbitration, we have to consider this to be a logistic tool here. It is not only logistic, it is also a financial tool. It is like a risk management tool. As a final word, what I wanted to say is that you all have to think about the superpower neutrality. Neutrality wins. Never ever agree to other parties' national courts. Don't enter into the court of another party. Never ever agree to a vague venue. Like, don't mention it India. Mention it Mumbai, India. Mention it Delhi, India. Be specific. And also just go with named institutions and commonly acceptable language. In that way, neutrality surely will win. When you are opting for arbitration, better in all your contracts go for arbitration. Why? Because when it comes to realizing, executing the outcome, the award, if it is arbitration, it can be enforced in major jurisdiction, any part of the world, any country. Assuming that the importer has assets in more than one country. In all those countries, you can take this arbitration award and enforce and realize your money. That's very important. But there are some procedures, but still it is enforceable. We need not start and waste another 5 or 6 years. with that award straightaway you can go and enforce it. Do not wait for the misdeeds or breach to happen. Do not ever wait for the standard terms which your counterparty wants to say. It is all about calling you for action. Now, just when you're trying to just go with this trade, global trade, take it in mind. Before you leave, take your phone, take a photo of the model clause, model arbitration clauses, which is available everywhere, whether it's whatever search engine you use. If you ask for a model arbitration clause mentioning two different nationality and a neutral one, it categorically gives the best one or the options. Once you get that, send it to your legal team or your legal advisor who is an external one. If you are a larger export house, you might have a legal team. If you are a small player, then you can very well approach an external counsel. They will just help you out to vet this particular document. Simply write to the other party, adopt this clause in all our contracts, the present one and the future ones. And it also has to be effected immediately, no exceptions. The other party, counterparty, would be happy to take it up. This is all about what the mindset we are going to have. When we are just going to get into the business, particularly global trade, we also have to be very, very cautious on how we are going to deal with the disputes. Disputes, as mentioned by ma'am, is inevitable. We have to encounter disputes. We have to use certain tools to effectively execute your contract. Thank you. Now I'll take the questions what has been raised. Ma'am, can you just read out the questions? I couldn't.
Yes, sir. Thank you very much, sir, for this insightful sharing. And we are having just one question. I can see from Mr. Ravinder Singh. He's asking, what are the major challenges faced in enforcing arbitral award across different jurisdictions?
Okay. When it comes to, as I earlier mentioned, when it comes to enforcement of an arbitral award, if the country where you are going to enforce it comes within or a member state of the New York Convention out of the 172 countries, then it is very simple. It is normally time from 3 months to 6 months. We can very well execute in that particular court. Not only that, the losing party, if they have assets, whether movable or immovable assets in any country, not only in their home country, any other country also, very well that can be enforced.
Thank you, sir. Thank you very much. I can't see any more questions. Still, I would ask the participants, if you have any questions and you have not posted yet, please do post. And later on, also, you can send us your questions over email and we'll get you connected with sir. So you can also have a direct conversation with him, or through chamber also you can reach to sir. So I think, sir, because there are no more questions and I can't see anyone writing here now. So I think we should be closing the session now. On behalf of the International Arbitration Centre, AECCI-IAC, I would like to thank you, sir, for your time, experience, sharing the knowledge. And it was indeed very insightful. And you have shared many good points at the end, but you have asked about the model clause. Here from IAC also, we keep posting the
Yes.
model clause to all our members so that they can be careful about this particular thing, because trade disputes, this is the very first point where the resolve, the solutions can be guaranteed. So this is very important to take care of all these points. And sir, once again, thank you very much for your time.
Thank you.
And of course, we'll meet soon again in some other session.